Welcome to the first of Tanfield's short series of 4 webinars dealing with matters commonly found in cases involving contested probate and disputes arising in the administration of estates. I'm Charles Joseph, and I'm joined by Adrian Carr, Gwyn Evans and Olivia Murphy. This webinar deals largely with the making of wills and the validity of wills, and I'm going to start things off by looking at Section 9 of the Wills Act 1837. Just before we get on to the statutory provisions, though, it's worth noting that a document which is not on its face a testamentary document can be included in a will by incorporation. The rule about the incorporation of testamentary documents of documents that are not testamentary documents is a common law rule, that is to say it's judge-made law, and the 3 requirements are that the document must be in existence at the time of the execution of the will, the document must be referred to in the will as an existing document, and it must be described clearly so as to be identifiable. Now, these are important requirements because otherwise it would be open to any testator to avoid the significant and essential formalities required for the creation of a testamentary document simply by making a new document from time to time without compliance with any of the statutory provisions. By way of a real-life illustration, I've just been involved in a very sad case where a wealthy professional in the financial services industry flew from England to a South American country where he committed suicide. He had made a homemade will before he left the UK, which referred to what he called a letter of wishes, but which was in fact a series of detailed instructions to his executors as to how to dispose of his estate. It wasn't clear whether he'd written out his instructions before he made the will or after it, because the wording in the will was ambiguous. There was litigation. The litigation was settled because neither side could be sure of winning, and this illustrates really the importance of complying with these 3 essential requirements if a document is going to be incorporated. Better still, a testator should be encouraged to ensure that the dispositions which he wishes to make are in fact set out in the will itself. Now, formal validity. This means in practical terms compliance with the formal requirements for making a will, which are largely to be found in the Wills Act of 1837. Formal validity should be contrasted with substantial validity, which means whether a will which is valid in form is in fact valid in substance, and we'll come on to deal with substantial validity in due course. Note, however, there is no particular requirement for any particular form or legal language for a will. If the document is intended to operate as a will, i.e. it was intended to be a will and its effect is dependent on the death of the testator, and it's to take effect only from the date of death, then it is a will, so long as there is compliance with the requirements for formal validity. Next slide, please. Section 9 of the Act. This requires a written document signed by the testator or someone in his presence and at his direction. The testator intended by his signature to give effect to the document as a will, and it requires that his signature is made or acknowledged by the testator in the presence of 2 or more witnesses at the same time, and it requires that each witness attests and signs the will or acknowledges his signature in the presence of the testator and the other witness. Note also that the witnesses don't need to know that the document is in fact a will. The essence of this procedure is the prevention of fraud by ensuring that the signature of the testator is genuinely his signature. And now I'm going to hand over to Adrian, who's going to deal with some other provisions in the Act.
Thank you very much, Charles. I'm going to deal first of all with the Wills Act 1837, Section 15. So if I could have the next slide, please. Thank you. You'll see from that slide that neither the a witness nor the spouse or civil partner of a witness can be a beneficiary under a will. So this isn't directed actually at the formal validity of the will itself. It's directed rather at the formal validity of particular gifts in the will, and that provides that where a witness has been given something under the will, the witness can't take that gift. It becomes invalid. Similarly, where the civil partner or the spouse of the witness of the will has taken a gift under the will, the witness or the civil partner simply can't take that gift. So, as a matter of practice, when you're writing to the testator or testatrix and you're sending a copy of their will for execution outside of your office, you should be sure to include a note advising the testator or testatrix about the effect of section 15 to ensure they understand that the witness and the spouse will not benefit if they are the witnesses to the will, and you've got to do this, otherwise you risk being sued by any beneficiary who might lose out. Now, the second thing I wanted to look at was some of the effects of Wills Act 1963. First of all, under section 1, we of course live in an increasingly global world, not so much at the moment. But we live in a world where we frequently come across wills executed abroad, and we are concerned to know whether that will be recognised as a valid will in the courts of England and Wales. So essentially, under section 1 of the Wills Act 1963, the courts will treat a will as valid if its execution conforms with the internal law in force in the territory where it was executed, or in the territory where at the time it was executed or at the date of the testator's death, the testator was domiciled or habitually resident. You should be very careful about domicile and residence. They have technical meanings. And when you may think that a person is domiciled in a particular territory, there is a risk that they won't be. So you need to look very carefully at what domicile and what habitually resident actually mean. Finally, the courts will treat a will as valid if it was executed in conformity with the law in force in the state of which the testator was either at the time of his execution or his death a national. So if a French person executes a will in the United Kingdom in accordance with French law, that will can still be valid. So the rub of it is, where you're looking at a will which may at first sight appear to be invalid in accordance with the provisions of section 9 of the Wills Act 1837, which Charles has just run through, pause before delivering that news to your lay client and just look for evidence that whether the will was executed abroad, evidence of the testator's domicile and habitual residence, and evidence of the testator's nationality. Do a little bit of research before you deliver your verdict on whether or not a will is invalid, otherwise you may end up getting a bit embarrassed. Finally, on this point, I just say you may need to get some expert evidence on the law of that territory to determine whether a will has been validly executed in that territory. The other provision I just wanted to have a quick look at is section 2 of the Wills Act 1963, and this deals with a series of miscellaneous situations, really. There are only 2 of those that I want to look at today, which are, I wouldn't say likely to arise in practice, but may arise in practice. The first is where a will has been executed on a vessel, on a ship, or on an aircraft. In that case, it may be found to be properly executed if it's been executed in accordance with the laws of the territory with which that vessel or aircraft is most closely connected. So you need to look at the vessel, look at the aircraft, see where it is registered, see where the ship comes from, who owns it, and determine the law with which it is most closely connected, and that is going to be the law of that ship for the purposes of making wills. And secondly, a situation which perhaps more commonly arises is where the will deals with immovables, i.e. real property, and it's executed in accordance with the law of the territory in which that real property is situated. In that case, it will be valid, certainly insofar as it deals with those immovables, that real property. So I'm now going to pass you on to Olivia, who's going to have a look at codicils.
Where a testator wishes to make minor changes or alterations in the terms of their will, such as adding to the number of beneficiaries or revoking legacies or increasing or reducing the amount of any legacy, this can be achieved by the use of a codicil. You must remember a codicil is a testamentary document, and so everything that you've just heard about the making of a will also applies to the making of a codicil. The formalities that must be complied with for a will to be valid are the same formalities that must be complied with for a codicil to be valid. You can have multiple codicils, and because of this, it is always sensible to state on the face of each codicil not only the date of the codicil and the date of the will it refers to, but also whether it's the first or second or third codicil, etc. And where a legacy is to be given by codicil to a person who is already a legatee under the will, it should be made clear whether the gift is in addition to or in substitution for the existing gift contained within the original will. Consider endorsing the codicil onto the existing will so that it cannot be overlooked or misplaced. Codicils have to be read and construed together with the will, so guard against any inconsistencies between the codicil and the will, but always consider, is it more appropriate simply to make a new will? Adrian was just telling you about section 15 and its effect upon gifts given to beneficiaries who then go on to either witness a will or their spouse witnesses a will. That also applies to codicils, so it is generally undesirable that a beneficiary under a will or their spouse should be an attesting witness to a codicil, even if that codicil does not deal with their gift. Codicils really should only be used for making simple amendments. There are sorts of things such as deleting a legacy to a beneficiary who's already died, or updating a statement of domicile. But if you create a lot of codicils, there can be confusion, and you should always give considerations to whether it's been more cost effective and simpler and clearer simply to draft and execute a fresh will. Alterations on the face of a will, these are okay if they're part of a will before execution, but in order to evidence this, a requirement for alterations to be made and initialed and signed by both the testator and the witnesses is in section 21 of the Wills Act. Gwyn.
Thank you, Olivia. Okay, the following impinge upon the substantial validity of a will. They are testamentary capacity, the testator's knowledge and approval, any undue influence applied, whether there was fraud, and any suggestion of forgery. All of these are frequently the subject of litigation, often prolonged and bitter, and much expert evidence is required. The key issue is that the testator must have known and freely desired to make the dispositions in a will. So I'm going to look at testamentary capacity. First of all, the testator must be over 18. There's a statutory presumption of there being no capacity for a minor. But following a case called Banks and Goodfellow from 1870, which is very well known, a testator must be of sound mind, memory, and understanding. Now, what does that mean? Minor defects in, for example, memory do not mean that there's necessarily a lack of testamentary capacity, which is the ability freely to make a will. Capacity can also fluctuate. So a testator may have capacity some of the time. For example, if there's a psychiatric condition which is controlled or partly controlled by medication. As for the sound mind concept, the testator must be capable of forming testamentary intentions expressed in a will. Now, the law does not call for a perfectly balanced mind. It's possible for someone suffering from mild or even moderate dementia to make a valid will. But equally, the fact that a testator can be capricious, mean, or spiteful doesn't mean that they can't still make a valid will. Nor is a will to be pronounced against by a court simply because the testator was moved by capricious, frivolous, mean, or even bad motives. So, if there is a suggestion that there might be a challenge to a will, then it's worth bearing in mind what is called the golden rule. So this would typically apply for an aged testator or someone who's been seriously ill, and the solicitor would arrange for a medical practitioner to satisfy himself as to the capacity and understanding of the testator and to make a contemporaneous record of that examination of the findings. And the learning there is from a case called Kenwood and Adams from 1975. And it's important where there's any reason to anticipate that there might be a challenge on the ground of lack of sound mind, memory, or understanding. Now, it's not always possible to comply with the golden rule. For example, you may have a patient, a client, who is unwilling to submit to a medical examination, unwilling to incur the cost, or there may be insufficient time to obtain such an opinion. However, Mr. Justice Norris said in Wharton and Bancroft in 2011 in the High Court that the solicitor instructed to prepare a will for a terminally sick client sent home from hospital knowing that he had only days to live was not to be criticised for deciding to make his own assessment, which the court accepted as correct, and to get on with the job of drawing a will in contemplation of marriage so that Mr. Wharton could marry. However, see also there's a case Burgess and Hawes from the Court of Appeal in 2013, where the value of an experienced solicitor's evidence comparing the view of an expert witness who had never met the testator unfavourably against the first-hand opinion of this independent professional solicitor was once again bolstering the concept that you didn't necessarily need to have an independent medical opinion. However, that has been criticised in later authorities, and the guidance given in that case is obiter dicta. So it seems to me that you are best advised to honour the golden rule if there is an issue. Now, sound memory means that a testator must be sufficiently able to recall the various individuals who ought to be considered as possible beneficiaries and the extent of the property which is his to dispose of. So he must not be affected by any insane delusion, i.e. believing without foundation that a relative is trying to poison him, but an insane delusion that the moon, for example, were to be made of green cheese, and which accordingly has no effect on his testamentary capacity, would not of itself invalidate a will. So looking at the testator's understanding, it must be sufficient to comprehend the various ties which possible beneficiaries might have with him, that's relatives and friends, and how and why they might have some claims to the testator's generosity. He must understand, at least in general terms, the extent of his own property. Now, mental incapacity can be age-related, as with senile dementia, or disease-related, as with schizophrenia. Perhaps it can be caused by psychiatric trauma, so extreme grief disorder, or by various drugs. These are all things to weigh into the mix. Now, as to the timing of when that capacity has to be had, the relevant time is the time of the execution of the will. So it's possible, for example, to have capacity on some days, but not on others, or even for any part of the day. But as long as you have it at the time you execute the will, that's fine. However, there's a case, Parker and Felgate from 1883, in which it is stated that it may be sufficient that the testator is of sound mind when he gives the instructions, and although he's not able to follow all of the provisions of the will when it comes to the execution, he appreciates that he's executing a will that is in line with his previous instructions, and that doesn't invalidate the will. The necessity, if this is brought up in litigation thereafter for there to be expert evidence as to capacity, means that there may be a request for the medical notes of the client, and those can typically be voluminous for someone in their 80s or 90s. And so to avoid a dispute about capacity is really quite important. Now, the burden of proof lies upon the person propounding the will to prove that the testator had testamentary capacity at the relevant time. There's various authorities on that, which I won't bore you with. But the following are rebuttable presumptions. Firstly, if a duly executed will is rational on its face, then there is a presumption that the testator had testamentary capacity. That's Sutton and Sadler from 1857. What about a mental illness? Well, if during a period prior to the execution of the will, the testator had suffered from a serious mental illness, a presumption arises that it continued and that the testator lacked testamentary capacity. So the person propounding the will may rebut this presumption by establishing that the testator made the will during a lucid interval or after a period of recovery. So that's about testamentary capacity, and I now hand over to Charles Joseph.
Thank you, Gwyn. I'm just going to deal briefly with knowledge and approval, because knowledge and approval is also one of the requirements for a will to be valid, or substantially valid. As Gwyn has alluded to, the party who's putting forward a will must show that the testator knew and approved the contents, because the burden of proof is always on the party propounding the will. So far as knowledge and approval is concerned, the starting point is that it is normally presumed because of the fact of due execution and testamentary capacity. But if doubts are raised about knowledge and approval, or in the words of the older cases, if there are circumstances which excite the suspicion of the court, then the party who is propounding the will has to produce additional affirmative evidence to prove positively that the deceased knew and approved the contents of the will. So, for example, you might have a blind testator and the attestation clause doesn't say that the will was read over before he signed it. Or there might be a particularly frail testator and the will has been arranged exclusively by the sole beneficiary of his estate. Or there might be mistakes in the will, for example, as to the contents of the will or the assets to dispose of. By way of an illustration, I've just advised in a case where both the testator and the testator's son lived in London. The testator owned a controlling interest in a family property company, also in London. The son instructed solicitors in Bristol to draw up a new will for his father, the father being 96 years old at the time. The solicitors never met the testator, they didn't correspond with him, and they didn't even speak to him over the phone. The testator had no connection with Bristol at all. The new will gave the son a controlling interest in the company. The son made an appointment with a London solicitor, and he then took his father there to sign the will in those offices. So in the words of those older cases, this is undoubtedly sufficient to excite the suspicion of the court, and in due course the son will have to prove that his father knew and approved the contents of the will by some form of affirmative evidence to that effect. I'm now going to hand over to Olivia to deal with undue influence.
Moving on to the next slide, undue influence is pressure exercised to overcome the testator's true will. Probate law differs as regards undue influence from equity in that the presumption which attaches to inter vivos gifts does not apply when considering testamentary dispositions. It is a question of fact. In reality, it's a high hurdle to clear. There is a 1920 case of Craig and Lamoureux in which the judge said that it is not enough to show that someone has the power unduly to overbear the will of the testator. It must be shown that in the particular case, the power was exercised and that it was by the means of that power that the will was obtained. And if you are challenging a will, you therefore have to prove that the person making the will was influenced to the extent that their free will was completely oppressed. The burden of proof lies on he who asserts, and whilst it is the civil standard of proof, do bear in mind the words of Mr. Justice Lewison in the 2007 case of Edwards and Edwards. when he said it is not enough to prove that the facts are consistent with the hypothesis of undue influence. What must be shown is that the facts are inconsistent with any other hypothesis. Now, in this context, undue influence means influence exercised either by coercion, in the sense that the testator's will was overborne, or by fraud. And by coercion, I'm talking about pressure, which overpowers the testator's wishes without actually changing their mind. It is more than mere persuasion, but pressure which causes a testator to succumb for the sake of a quiet life, if carried out to an extent that overbears their free judgment, will amount to coercion in this context. And when one's considering whether or not the persuasion has reached the level of coercion, the physical and mental strength of the testator are relevant factors. The will of a weak and ill person may be more easily overborne than that of a well and happy person. Consider the drip, drip, drip approach, which may be highly effective in sapping the will. Another species of undue influence is fraudulent calumny, which is a phrase, a wonderful phrase, almost as old as equity itself, and Adrian will be advising more on that in a moment. But when one is considering undue influence, always remember the question is not whether or not the testator's testamentary disposition is fair. The question is only, did they act as a free agent? And as a practice point, claims for undue influence are notoriously difficult to prove, so always carefully consider the quality of your evidence prior to pleading the same to avoid adverse consequences. Adrian.
Thank you very much, Olivia. As Olivia just said, I'll be looking very briefly really at fraud. Now, fraud really is not really much more than a species of undue influence in this context, insofar as it requires that the testator's true testamentary wishes to be overwhelmed by the activity of somebody else. The key difference between the classic undue influence, which Olivia has just described, and a fraudulent form of undue influence, is that there needs to be some sort of deception or dishonesty for fraud to arise. That's not necessary for undue influence. As Olivia said, all you need is a form of coercion or pressure. But with fraud, you need the deception and you need dishonesty. So that is the touchstone for fraud to arise. And as Olivia said, the classic formulation of this kind of fraud is the cause of action known as fraudulent calumny. Now, this arises where one person, A, poisons the testator's mind against another person, B, who would otherwise expect to benefit under the testator's will. And A does this by casting dishonest aspersions on B's character, so that the testator makes a will which excludes B from benefiting. Now, if that is what happens, the will has to be set aside. So the essence of fraudulent calumny is that A must either know that the aspersions about B are false or not care whether they are true or false. But where A honestly says that what he has said about B is true, then even if what he tells the testator is objectively untrue, the will's not liable to be set aside on that ground alone. It needs to be something which A knows or is reckless as to whether it is untrue or not. Lastly, I just wanted to mention forgery. Now, forgery usually occurs in the context of signatures, whether that's the signature of the testator, him or herself, on the will, or the signatures of the attesting witnesses. Now, where it's alleged that a signature has been forged, you will almost always need to have some form of expert handwriting evidence to deal with that question. It's a question of fact. Is the signature appearing on the will the true signature of either the testator or the witness? Now, the court, of course, isn't equipped to make that decision itself, and it needs expert opinion evidence to decide it. As a matter of practice, it's frequently the case that lay clients will come into the office and suggest that the testator didn't execute a will. You've got to be careful about this. That they often do that because the signature on the will doesn't resemble how that person thinks the testator's signature actually looked. But you've got to bear in mind that the testator's signature is almost certainly going to have changed over the years as the testator gets older, and of course as the testator gets more frail, and particularly where the testator has some physical affliction or disability which affects the use of their limbs, and in particular their arms and hands, which will impact upon the way in which they make their signature. So you have to be very careful about it. You've also got to be very careful about suggesting that a signature has been forged where it's been witnessed by two attesting witnesses, and those attesting witnesses are willing to come to court to give evidence to say that they did witness it. Because in that case, you're going to be setting up an expert report, which presumably says the signature has been forged, against the witness evidence of fact of two people who were there and saw with their own eyes the testator executing the will. That is going to cause the court difficulty, because the court is always going to prefer, almost as a natural matter of fact, it's going to prefer the witness evidence of fact rather than the opinion evidence of someone who was not there when the will was supposed to have been signed. So that deals with forgery. I'm now going to pass you back to Charles for a few closing words.
Thank you, Adrian. Thank you everybody for viewing and listening to this webinar, which was the first in a series of 4. The second one is going to deal with a number of disparate issues such as statutory wills, the technicalities of different grants, rectification, estates with property in EU countries, and some points on tax. Thank you all once again, and this webinar is now concluded.